paying that in the first plan.
Right, but isn't that something that would be agreed upon before? I mean, wouldn't that be taken care of? I'm asking
No.
the sentence there.
Okay.
And the other, the other part of that is, of course, the Affordable Care
Right.
Act. Those are the two things that I'm interested in. Why doesn't this language address
Give
it?
me two answers. First, I don't know what you signed when you guys joined PERS. And you may have agreed to some things I just simply don't know about.
Yeah, we've
I just
got
read
to
it.
do this.
Moving to the pension. Nobody signed in a compliance agreement or a collective bargaining agreement that went into withdrawal liability. Nobody did. Nobody even thought about that until after beginning of this century, and then in particular after 2008. Those are imposed by the federal government, particularly by the IRS rules. The plans are required to be audited every year. The actuary figures out the funded status.
We have the new Gatsby rules that are coming out.
Right. All those things apply. And then depending on the level of unfunding, you have certain federal requirements of the plan and the participating employer. This stuff is not in any collective bargaining agreement. When I get letters from employers, that's usually the first thing I say is like, hey, I didn't make this rule, and nobody we don't like these guys any more than you do, but let me tell you what your obligations are, and we go through that. And that's really what I'm doing here. It's like, unions didn't make the rules, city didn't make the rules, the government made the rules, and for these underfunded plans.
So I'm still slightly confused.
I think you're asking whether that last sentence
Right.
would apply to withdrawal liability,
Right.
and you've already agreed to it. I think you're raising a good point. The part that I think gets confusing is I'm looking on page 6 of the ordinance under E, and I've read that paragraph a dozen times, and I really can't figure out what it's saying. The first sentence says benefits and eligibility criteria shall be the same for all eligible employees. That would seem to require withdrawing from any other type of plan. I mean, when you have PERS, you have the
So that's where you
electrical
feel that we
plan.
maybe need to strengthen the language or
Well, I just don't understand how that sentence, then you get the next one, which seems to allow opting out. Those seem to conflict with one another. And then the third one I see as a reference to withdrawal liability, but I'm not totally sure. And then when you flip to page 28, under 370.170, the paragraph talking about all, unless specifically exempted by ordinance, all municipal employees shall be subjected to municipal leave policies and benefit programs as defined under personnel code. That seems to require uniform benefits, and I don't see where in there there's an ability to opt out, and it would seem to require the withdrawal from all these pension plans as well. And I mean, they're different plans, so I don't know how you have uniform.
I guess it's how you read it. I'll have to get some further.
Our point was that the city already participates in plans which incur penalties by special tax or otherwise. Since you already do that, and since this would make that illegal, then you have to withdraw from those plans.
Right, and I guess where I see that sentence, it says unless previously agreed upon, so that's why I'm confused.
For the construction industry plans, there would be no previous agreement. I don't know about PERS, but I represent construction industry plans. It's unheard of. There are, because
So then maybe the PERS wasn't the right example, maybe?
PERS is, I use PERS because if you withdraw from PERS, you have a huge liability, and you're already in an unfunded plan. So it was easier then to move over. There are other unfunded plans, and these plans have triggering mechanisms. So if you pull out, then you trigger withdrawal liability. And when you trigger withdrawal liability, the assumptions change, and the assessment of liability is it's huge.
Thank you.
Mr. Trainee?
Mr. Chairman, last Friday, I had to run out of town, so I was flying out. I asked Paul to ask a question, which he did. I want the administration to tell me that my billable hours have been put into 3.70 by the legal department by individual. Now, we'll see how much money to spend on this. And before I vote on this, I expect to have that 26th or 27th, when I even get it scheduled. I want to have that information. To the unions, Seattle, did you figure out what they've actually outsourced? Do you know the programs they've outsourced?
I don't know what they've outsourced.
I'll find that out.
We can
Going to
provide that
42.
information to you, though.
So would you slip to slide 42 for a second?
Sure, I'd be happy to.
You've got transfer of power from the assembly to the mayor. My concern is this is a charter change without the benefit of going to the public for a confirming vote on that. And I would anticipate we're gonna have numerous lawsuits filed against the city relative to this, because this is simply a massive charter change without the benefit of going in public's view on it.
I would agree with the Assemblyman's characterization of that there are legal problems fraught here because essentially you are using through the ordinance process, making the types of changes that one would expect to be made in a charter amendment. And that will undoubtedly, should this pass, cause legal challenges. And those will be expensive, and they'll be time-consuming, and they will create a host of problems, which is why, at the conclusion of my presentation, I said, by passing this, you're opening Pandora's box.
Or Sullivan's box, depends on your point of view. Julia, can we bind future assemblies?
We do.
Can we? Is there any prohibitive?
Anytime that you pass an ordinance, you are binding the future assembly to that ordinance until they change that ordinance by ordinance.
Have you gone through 3.70 yourself?
I have.
Okay. Which, have you given us your impression on it?
I haven't given anybody my impression of it.
Let's have it in writing, would you? Because you're our attorney and I trust your opinion. Thank you. That's all, Mr. Chairman.
Mr. Trombley?
I'm sorry, I forgot your name.
Mike Tedesco.
Mr. Deskin.
Thank you, sir.
The term direct labor cost, what you're saying, well, one of the things that you mentioned was that it's not a commonly used term in labor practice.
Right.
I understand the purpose behind it from the administration standpoint of what is the actual direct labor cost, the total cost of the employee to the municipality.
Well,
And that's just like in the private sector. If you pay somebody a wage of $15 an hour, it actually really costs the employer $25 an hour when you calculate taxes, benefits, all that kind of stuff. Are you saying that the term shouldn't be used at all, or that it should be better defined?
Well, whenever you deal with a term in an ordinance or in a law, the first thing that you look at in terms of constructing what that means is you look at the context that it's presented in within the context of that law. That's the first rule. Here, direct labor costs, and I'm trying to get it up on the screen here, folks, to try to make this a little easier, talks in terms of benefits, and it talks in terms of taxes, and it talks in terms of pay enhancements. And none of those terms are adequately defined. So if the definition that direct labor costs is based upon is not adequately defined within the law that you're passing, then the term direct labor costs in and of itself is not defined well. Now, perhaps you could cure that if this were a term of art in the labor relations world, but it's not. It's the type of thing that, we all kind of sit back and go, well, you employ this person and you've got the cost of wages and you've got what amounts to what we commonly refer to as roll-ups. And that's the cost of providing Social Security, and that's the cost of providing some level of employee benefits. But without precision, how will this assembly deal with the labor contract? Let me give you an example. Let's say you've got a police department with, Derek, how many members do we have?
500.
500. And let's say due to growth, because of all the wonderful work you folks do, now we've got a larger population and we need 1,000 cops. What's a future assembly going to do when the payroll doubles in the police department? What are you going to do when you look at the CPIU when that next labor contract comes up and now all of a sudden your labor costs are 100% more? Is the labor cost pegged to the individual cop? Is the labor cost pegged to the individual bargaining unit? all the language says it's pegged to the contract. Well, the contract represents everyone. So if you add 500 more comps, to use an absurd example, but it would work with 20 or 30 or 40 or 50 or 100. The assembly that's sitting at the time that increase in members takes place would be totally puzzled as to what to do. Because you can only raise the direct labor costs, however you choose to define that, by what the cost of living index is. This last year, depending upon which cost of living index it is, and admittedly that's not well defined either, you know, most cost of living indexes were in the vicinity of 1.5% to 3%. So you've got a 3% growth, but you've got a doubling in the size of the department. What do you do? How can you fund it? That's the problem when you use undefined terms. That leads to contentious bargaining. It leads to political fights that are totally unnecessary. Look, I think part of what's going on here is that some of you may be upset with the way things got bargained in the past. I can tell you from my work on cases here, and Mr. Earnhardt and I have gotten to know each other pretty well, that I've gone back and I've looked at the bargaining history in the police unit as it's evolved over time. And you know, the one thing that strikes me as just, frankly, a little bizarre, there's never the same people at the table on the municipality side. It's a revolving door. So policies that were in place back in the bargaining of the 1990s are not in place now because people keep changing on the municipality side. In other words, I think you're trying to fix a problem through legislation that's a management problem on the muni side. And so the sorts of issues that are being discussed, this direct labor cost issue, whatever that means, is the type of thing that if you establish goals and practices in bargaining on the management side, you should be establishing those in the long run, not the short run, and effectuating those goals. And that's what I would suggest is the solution to the problem to the extent that you believe there is one.
If I could just continue on that a little bit, I think this is one of those areas where the lack of definitions is going to be really problematic. So, I mean, what it says on page 6 under D is that no collective bargaining agreement will be ratified by the Assembly if the percentage increase in direct labor costs associated with the agreement will exceed CPI. Associated with the agreement. So you have 1 year, like he's saying, where you have 500 police officers and the next year you have 1,000 or whatever. The direct costs associated with that agreement have doubled. Does that mean that all wages have to come down by 50% in that year in order to make it so that it's not going up by more than the CPI? A year where you have a lot of overtime because of a lot of storm outages at the electric utility, does that change? It would seem to change the percent of labor costs associated with that agreement. So, I mean, you're going to have years with fluctuations of overtime, of people cashing out a lot of leave.
Sure, I understand that. Could it not be argued, though, that you said something right before you stopped talking to me? It was in regards to
I was talking about the continuity of the
right.
city's
It was about
approach.
policy. Yeah.
Yeah.
Couldn't it be argued that very problem, the lack of consistent policy, which policy changes with politics, it changes every 3 years, change every 2 years on the Assembly. Could it not be argued, though, that by codifying particular language, you avoid that policy debate, and so now you actually will have some sort of consistency?
You know, I don't agree with that, and let me explain why. I often hear folks like yourself that, you know, take the sometimes thankless job of running for office saying, you know, we should run it more like a business. Government needs to be run more like a business. That if the public sector were treated like the private sector, you know, this all would be better. Well, in labor relations law, the private sector is the National Labor Relations Act. It is the decisions of the NLRB. It is the decisions of the US Supreme Court and the courts of appeals throughout the country. What we're asking is that the municipality run like the private sector. The private sector, yeah, any big organization, and certainly this is one, is going to have fluctuations, inefficiencies, mistakes. We're all human. Human beings run large organizations. And so but to legislate based upon, and to do something completely new, which is what's in front of you, and to get away from what's tried and true in the private sector, is a colossal mistake. Because you're asking more questions than you can answer. And particularly where you're putting into an agreement or into law undefined terms, you're frankly stepping into an abyss.
Sure. No, I understand that. I have one other question, Mr. Chairman. I've heard the term